Riley Bibby, Your Honour, appearing for the defence of Marshall Ike, charged with 84 counts of breaking and entering and 1 count of stealing. The Crown's case relies exclusively on purported admissions made by my client. I, however, have been instructed by my client to submit a plea of not guilty. The defence asserts that the evidence submitted by the prosecution should be excluded at Your Honour's discretion on both public policy and fairness grounds. As you can see, the evidence submitted is the police record of interview conducted with my client, hereby referred to as the interview, and documentation of purported admissions made by my client to police in the car while being taken back to the station, hereby referred to as the documents. The defence argues first that procedural requirements have not been adhered to during the questioning of my client, resulting in the aforementioned evidence, namely the appropriate cautions under the Police Powers and Responsibilities Act 2000, hereafter referred to as the PPRA, were not administered by police pursuant to sections 418(1)(a) and (b) and 431 of that Act. These cautions are, of course, my client's right to communicate with a friend, relative, or lawyer, and to arrange to have that person present during questioning, as well as my client's right to silence. The Responsibilities Code, that is Schedule 9 of the Police Powers and Responsibilities Regulation 2012, stipulates that the police were required to inform my client in a way substantially complying with that outlined in Section 23(1). Furthermore, Section 23(2) and 3 indicate that if the police officer reasonably suspected that my client did not understand the above information, that officer should have taken steps to further explain my client's rights and ensure they were understood. There is no evidence to suggest that this caution was ever administered to my client at all, let alone in a manner that he could reasonably be expected to understand. Regarding my client's right to silence, the Responsibilities Code, Section 26(1), states that the police officer was required to caution my client on his right to silence prior to questioning. There is no evidence to suggest that such a caution was administered to my client. In fact, my client was informed by his purported support person that he was to answer the questions the police asked him. This person was supplied by police and not selected by my client in violation of Section 421(2)(a) of the PPRA. Furthermore, it is unclear whether this person is on the list of supported persons provided for in Section 440 of the PPRA, or whether a parent or guardian, lawyer or legal services professional, adult relative or friend acceptable to my client were even contacted prior to providing my client with this person, pursuant to the PPRA Schedule 6 definition of support person, subsection B. The exception contained in Section 441, subsection 1 of the PPRA cannot reasonably be found to have applied. There was no reason to suspect that my client had an accomplice or accessory to his alleged offences, nor to believe that evidence was being concealed, fabricated, or destroyed, given my client's apparent willingness to cooperate. Furthermore, there is nothing in the circumstances of this case to suggest that, pursuant to Section 441, subsection 2, having regard to the safety of other people, the officer could have reasonably suspected that questioning was so urgent that it could not be delayed. As such, compliance with Sections 418 and 421 cannot be excluded. 5 factors inform the decision to exercise the public policy discretion to exclude, formulated in Bunning and Cross: whether the conduct resulted from genuine mistake or deliberate breach of law, the cogency of evidence, if the evidence was gathered due to a genuine mistake or was of a perishable nature, the conduct was a genuine response to pressing circumstances, the gravity of the charge against the accused, and if the conduct in getting the evidence breached a statute. The document and the interview are each evidence obtained through deliberate and improper police conduct and failure to comply with strict statutory requirements surrounding the questioning of a child. Furthermore, my client's admissions can hardly be considered perishable in nature, nor can the police conduct be considered a genuine response to pressing circumstances, as none existed in this case. Finally, Your Honour, Section 420 of the PPRA contains similar safeguards to that contained in 421, as Indigenous people are vulnerable witnesses in the same way that children are, as per the reasoning of Justice Forster at 413 in the Crown against Anunga. If the Indigenous person is also a child, as is the case for my client, though Section 421 is the applicable provision, the existence of protections for Indigenous persons implies that an Indigenous child is even more vulnerable. As such, there should be even more motivation to enforce the protection statutorily afforded my client. The defence asks that Your Honour exercise your discretion on public policy grounds pursuant to Bunning against Cross to exclude both the document and interview submitted as evidence by the Crown. Failing that, the defence applies to exclude evidence under 130 of the Evidence Act 1977. This is the statutory provision of the Christie discretion adopted in Australia as the Lee discretion by the High Court in the Crown against Lee. Lord Moulton in Christie stated that it would be unjust to admit evidence of a character gravely prejudicial to the accused, even though there may be some tenuous ground for holding it technically admissible. If such a case arises, the judge may intimate to the prosecution that the evidence, though admissible, should not be pressed because its probable effect would be out of proportion to its true evidential value. My client's Indigenous background is recognised as being associated with various cultural obstacles, especially as it regards answering questions posed by authority figures. It is evident that my client's admissions are the result of gratuitous concurrence, that is, the cultural phenomenon leading a person to assent to every proposition put to them regardless of the truth of the matter. This is not true evidential value. When questioned about breaking into the 84 properties pointed out by police, my client answered in the affirmative to all of them. The likelihood of this alone is very slim. When this considered as well with the powerlessness my client must have felt as an Indigenous child unexpectedly confronted by white authority figures, it is easy to see that these admissions are highly prejudicial. As such, the defence asks that Your Honour exercise the Lee discretion to exclude both the document and the interview. The defence concludes and defers to the court's authority.